Good afternoon. Before I begin, I would like to congratulate Professor Sylvain Leloux and the rest of the organizers of this so wonderful conference. I'm very happy to be here to share with all of you some ideas that I'm working in. And I would also like to express my gratitude to Professor Jeremy Espresso for giving me the opportunity to participate in the Garcia project, which is being a rich opportunity to learn from so many people. My paper is inserted in a broad research that I have just begun, comparing current pension reforms in some countries of Southern Europe. I'm interested in these processes of reforms because of two reasons. On the one hand, because these legal changes are taking place under an austerity orientation, which may lead to a regression in the protection level of its social security systems. And on the other hand, because the European Union, through instruments of coordination of economic and fiscal policies, may be shaping a matter of a domestic competence. What I intend at this stage of the research is to establish some preliminary points on these two aspects, taking the Spanish pension reform as a case study within the Southern context for its further development. So all your comments and suggestions are very, very welcome. European pension systems are undertaking changes of different intensities from the beginning of the century due to concerns on its financial sustainability. One of the major problems that traditionally have challenged pension systems is related to demographic projections, which seems to foresee an important aging of the population towards the middle of the century, when the baby boom generation reaches retirement age. However, this reforming trend has been especially intensified in some countries in the last years with economic, financial, and public debt crises. Relating these two relevant points should be considered when assessing pension reforms with regards to a temporal dimension of both challenges. Aging of population is a long-term problem, and current economic crisis is a short-term problem. So, legal solutions and policies need to identify which are the specific problems and which may be the better solutions. For instance, to face current financial crisis, it's possible to use other economic sources, such as in the Spanish case, the reserve funds, instead of introducing some reforms such as changing the indexation system. A feature of the last wave of reforms is the rise of the European Union institutions in a domestic regulatory environment. Hence, in the last years, the European Commission has considered the need to address the question and coordinating a debate resulting in the white paper on pensions, which constitutes a broad strategy to guarantee sustainable and adequate pensions. There are two main areas in which the Commission insists. On the one hand, the need of obtaining a better balance between years working and years in retiring through different formulas such as linking the retirement age to gains in life expectancy, or supporting a longer working lives. And, on the other hand, by promoting complementary retirement savings. Nevertheless, it should be noted that it's not easy to introduce these proposals in some countries. For instance, longer working life is quite difficult in the context of a high unemployment, especially among older workers. Or regarding complementary private pensions, we can wonder how workers with fixed-term contracts or in a part-time contract with low wages, or those who are unemployed, will be able to invest in these funds. The white paper is inserted in the framework of the Europe 2020 strategy and the new economic and fiscal governance, a complex set of different initiatives to coordinate economic policies. Instruments included there are aimed to prevent and control macroeconomic imbalances through imperative monitoring of indications. In this sense, public pensions expenditure represents a substantial part of public expenditure. For this reason, it's not surprising, therefore, that within the European semester, for example, country-specific recommendations often comprise indications on social security systems. The set of recommendations included in these different instruments can be found later in domestic reform content, as will be seen in the Spanish case. So, on the one hand, it's necessary to focus on these formulas of economic coordination to clarify the connection with countries' legal regulations and assess its ability to influence and shape domestic pension reforms. On the other hand, the European Union approach to domestic pension systems from the perspective of the budgetary surveillance mechanism with the aim of its financial sustainability seems to not have in consideration, for instance, the cross-cutting general principle settled in Article 9 of the Treaty of Functioning or the social protection objectives recognized in Article 151 of the Treaty. It should be explored whether coordination of social security policies through competences settled in Article 153 and 156 could be developed to consider also what recently the OECD has called social sustainability of pension system reform. Considering the Spanish case, austerity is the context in which system reforms have taken place for the past 5 years. Two important circumstances relating this can be underlined. The controversial amendment of Article 135 of the Spanish Constitution, which introduced the principle of budgetary stability, and the soft bailout addressed to save the financial and banking systems. As a consequence of these reforms, especially those introduced during the current conservative government, a clear regression of the system can be seen. Amendments to public work-like pension systems in Spain have been parametric, at least as we've been seeing in appearance. A first piece of the reform package was passed in 2011 after achieving previously a social and political pact. This reform increased the ordinary retirement age from 65 to 67, gradually maintaining the age of 65 if a higher contribution period is realized. It also increased the period of time used to calculate the pension from an average of contribution during the last 15 years before retirement. It has been raised to 25 years. And time of contribution need to achieve the full pension has also been raised from 35 to 37 years. And on the other hand, the early retirement age has also been raised from 61 to 60. The second big piece of the reform introduced two very important questions. On the one hand, the sustainability factor, which allows to link the amount of retirement pensions to pensioners' life expectancy at 67 years old, which represents a quiet shift of pension system. And on the other hand, a new indexation mechanism that considers interannual variations of income, contributory pensions, and expenditure of the system instead of considering the traditional consumer price index. The Spanish case has some convergences and divergences when comparing it to what is happening in other southern countries such as Portugal or Italy. It reveals, at least at this very superficial approach, common paths in reforms considering the European Commission's recommendations. Relating the convergences, the enlargement of the ordinary age is a common trend, also with some differences between Portugal, Italy, and Spain. And the most salient contrast is found in Italy, where the defined benefit system has shifted to a national defined contribution system, while Portugal and Spain still have a traditional pay-as-you-go system. However, it has been suggested that the introduction of the sustainability factor both in Spain and Portugal has transformed de facto the traditional defined benefit system into defined contribution one. Changes in employment relations and labor regulations affect daily living and working conditions, which become precarious for an increasing number of people. In the Spanish case, for instance, there is a high unemployment, and legal reforms have not adequately solved this problem, but has given rise to what has been called as a flexi-precarity model. While flexibility is expanded, facilitating the termination of the employment contract, security mechanisms such as training or unemployment benefits have a weak recognition. Doing so, the equilibrium between the two antagonistic components is broken. The consequence is more inequality between employer and workers and an increase of the judicialization. Considering that many pension systems, such as the Spanish case, are strongly linked to the development of a working activity, changes in employment relations and labor regulations might indirectly condition the access to pensions, so they should be considered when reforming pension systems. Among the questions that should be taken into consideration regarding the subsequent impact on pensions, it can be highlighted the high number of unemployment periods, the spread of new forms of employment, part-time, fixed-term contracts, the decrease of wages. The Bilbao Moreno case is paradigmatic of how pension regulations many times do not fit properly with labor regulations. Connections between current precarious forms of employment relation and pension regulations should be adjusted to increase an appropriate protection for those workers and citizens at large who do not fit the standard model of worker upon which social security regulations have been built. Otherwise, precarization of working conditions and the tightening of conditions to access and calculate a pension can lead to a fragmentation of retirement protection. In this sense, it's interesting the idea of a basic income for older people, which takes into consideration the existence of a non-standard life course of employer, with the idea of socialized pension risk. In my opinion, these reforms are shifting risk sometimes from a shared perspective amongst shared employer and workers to these lectures individually. To conclude, I think that international regulations and codes may play an important role in counteracting the regressive effects of austerity on pension systems. Among the different international instruments, I would like to highlight the European Social Charter and the role of the European Committee of Social Rights. A good instance can be found in the cases against Greek anti-crisis measures in application of the Memorandum of Understanding. The European Social Charter importance becomes even more important, even more significant when it's applied by some domestic judges and courts to reduce regressive consequences of legal reforms. A recent judgment of the Labor Court of Barcelona is an excellent example of this. The role of constitutional courts in some European countries applying national constitutions is also relevant. The Portuguese Constitutional Court, facing issues that reduce pensions of retired civil servants, or the Italian Constitutional Court relating the non-indexation of some pensions are good examples. However, we can find also other examples in which constitutional courts have not considered the unconstitutionality of these measures, such as in the Spanish case. Many thanks and thank you for your attention.